Welcome to the deep dive. Pull up a chair, grab your notes. Today we are plunging headfirst into one of the most fundamental and, let's be honest, sometimes thorny areas of intellectual property law, the criteria for patentability. What makes an idea, or more accurately, an invention, eligible for that coveted government-granted monopoly? We've been poring over a really comprehensive stack of sources for this deep dive, a fantastic set of notes and readings, which I want to specifically credit to the University of London for making these invaluable materials available to students. And speaking of students, if you're using this deep dive to get ready for an exam, a huge good luck to you from us. This deep dive is specifically designed to help you get a handle on the core principles and key cases. It's brought to you by Sinorbit Academy, Sri Lanka, and our mission is to help you cut through the complexity and get straight to the understanding you need.
That's right. Whether you're an innovator hoping to protect your next big idea, a business navigating the competitive landscape, or, as you mentioned, a student aiming to master this subject, understanding the rules of patentability is absolutely non-negotiable. We're going to break down the core requirements. You can think of them as, well, 3 positive hurdles you need to clear, and 1 major category of things that are simply excluded, no matter how clever they seem. Along the way, we'll explore the crucial case law, drawing from both the UK courts and the European Patent Office, because the law here, particularly the UK Patents Act 1977, is heavily influenced by the European Patent Convention. You really need to look at both to get the full picture.
Okay, so what exactly are we aiming to achieve in this deep dive into the source material today? What's the mission?
Our goal is to demystify these criteria. We'll start by tackling a seemingly simple question that's actually sparked huge legal debate. What even counts as an invention in the first place? Then we'll spend significant time on the negative exclusions, what kinds of things the law explicitly says you can't patent, and crucially, why. After that, we'll walk through the 3 positive tests. Novelty, is it new? Inventive step, is it non-obvious? And industrial application, is it useful? Highway. For each one, we'll dig into the key concepts, the tests courts apply, and, the landmark cases that have shaped their meaning. By the end, you should have a really solid grasp of the principles and how they're applied in practice.
All right, let's unpack this complex but, I think you'll find, surprisingly fascinating world of patentability and extract those crucial nuggets of knowledge from these sources. So before we even dive into the specific list of requirements in Section 1 of the Patents Act 1977, which is the starting point for defining what's patentable in the UK, is there a separate, perhaps even more fundamental question? Does something have to be considered a legal invention before you even check if it's new, non-obvious, etc.?
Yes, this is a perfect place to start because it's a point that has caused, well, a significant amount of head-scratching and judicial debate over the years. Section 1 of the UK Patents Act 1977, as you rightly pointed out, is based directly on Article 52 of the European Patent Convention, or EPC. It lists the requirements. An invention is patentable if it's new, involves an inventive step, is capable of industrial application, and isn't excluded. The wording is, an invention is patentable if it complies with the following provisions. That is to say.
And that is to say, wording seems to suggest the list is the definition, doesn't it? Like, if you meet the list, you are an invention.
Precisely. And that was part of the debate. Historically, UK courts were genuinely divided on this. In some of the early cases grappling with groundbreaking new technologies like recombinant DNA things the law hadn't really seen before the question arose. In Genentech Inc.'s patent, for instance, involving a method for producing human tissue plasminogen activator, some judges, like Mustel LJ, leaned towards the idea that there was a separate preliminary requirement, a kind of intrinsic quality perhaps, that something had to possess to be considered an invention in the legal sense, over and above simply meeting the listed criteria.
Okay, so one view was it's a separate hurdle.
Yes. But then, a different formation of the Court of Appeal took a different view in Chiron Corporation v. Technica Ltd. This case was about diagnostic methods for hepatitis C. The court there suggested that the word invention in Section 1.1 simply meant something that satisfied the listed criteria of novelty, inventive step, etc. This perspective actually aligned with the thinking at the European Patent Office at that time and seen in decisions like Howard Fleur Laxon, and that is to say, phrase in the UK Act seemed to support this combined approach, implying the list was the definition.
Okay, so we had this split in the UK courts. Did that divergence get resolved? I mean, where did it land?
It's not definitively by the UK courts alone, no. The debate continued, even making its way to the House of Lords in the very significant case of Biogen v. Medeva. This is a landmark case, often cited in patent law. And again, you saw different views. Lord Hoffman advocated for the view that there's no separate concept of invention beyond meeting the listed criteria, essentially endorsing the Chiron approach. But Lord Mastill, consistent with his earlier view, maintained that there was a distinct question of whether something was an invention in the first place.
So even the highest court wasn't unanimous.
Exactly. So even the highest court in the UK at the time wasn't fully unified on this point.
So what's the current position? How do courts and the EPO generally approach this initial hurdle now?
Well, the prevailing position today, particularly reinforced by the current case law from the EPO Boards of Appeal and supported by the wording of Article 52 EPC in both its 1973 and later 2000 versions, is that an invention is a separate prerequisite. It's a preliminary test, you see, that must be passed before you get to novelty, inventive step, and industrial application. It's very broad, but the key determinant is the presence of technical character. This is the crucial nugget from this historical debate.
Technical character. Could you break that down for us? What does that actually look like in practice?
According to important EPO decisions like PBS Partnership Controlling Pension Benefit System and Hitaki Auction Method, technical character means the invention must be concrete, not purely abstract. It implies a physical entity, a process involving physical means, or something that is man-made and serves a utilitarian or technical purpose. Think about it this way. The patent system is designed to protect technical solutions to technical problems. So purely abstract ideas like a scientific theory on its own, a mathematical method, an economic calculation, or a rule for playing a game in isolation generally lack this necessary technical character. They aren't considered inventions in the patent sense at this initial stage.
Okay, I think I'm getting it. So the very first filter is, does this thing, whatever it is, have a tangible aspect, a physical effect, or a technical application? Is it rooted in the physical world, designed to do something useful, something technical?
Exactly. It needs to have that foundation of technical character. It needs to be something that a person skilled in a technical field could make or do, aimed at a practical technical result. This threshold isn't extremely high, but it's essential. If it clears this technical character hurdle, then you move on to examine if it's new, inventive, and useful. This focus on technical character as the initial test is refined in later EPO cases like Dunn's licensing associate estimating sales activity and forms the basis of the modern EPO approach. So remember, step one, technical character.
Okay, so assuming something clears that initial hurdle
Yeah.
and has technical character, what then is explicitly prevented from being patented, even if it seems new and inventive? These are the exclusions, right?
Correct. This is the negative side of the patentability criteria, the excluded subject matter. This is primarily covered in Section 1.2, Section 1.3, Schedule A2, and Section 4A of the UK Patents Act 1977. Again, these provisions closely mirror Articles 52 and 53 of the EPC. The sources group these exclusions into two main baskets.
Yeah.
Those excluded because they are deemed to inherently lack technical character, even if they seem to on the surface, and those excluded for public policy or morality reasons, even if they do have technical character.
Let's start with that first group, the ones related to lacking technical character under Section 1.2. What's on that list?
Section 1.2 lists several categories: discoveries, scientific theories, and mathematical methods.
Right, the abstract stuff.
Exactly. Then aesthetic creations.
Art, music, things like that.
Yes. Then schemes, rules, or methods for performing a mental act, playing a game, or doing business.
Okay.
Presentations of information,
How things look.
pretty much. And finally, computer programs.
That list again sounds quite broad, covering things that might be seen as innovative in other contexts.
It absolutely does. And this is where a really crucial phrase comes into play, both in the UK Act and the EPC as such. This two-word phrase is central to understanding these exclusions. Patentability is excluded only to the extent that the patent application relates to these things as such.
As such.
As such. This means you can't patent a scientific theory on its own or a business method purely as an abstract set of steps. This qualification is incredibly important, and it means how the claim is worded in the patent application is vital. Section 14.5 of the Act emphasizes this. A clever patent attorney will draft claims not for the excluded subject matter as such, but for a technical implementation or technical application of it.
So what does as such mean in practice? How has that interpretation evolved? Because that sounds like the tricky bit.
It is the tricky bit, and this has been another area of significant legal development and, frankly, some confusion, especially in the context of computer programs and business methods. The original approach at the EPO, seen in the famous Vicom computer-related invention case from the 1980s, was the whole contents approach. The idea was to look at the claimed invention as a whole and ask if it produced a technical advance or a technical effect. If an invention was just a quicker or more efficient way to do something that was previously done manually or mentally, even if it was economically beneficial, it might not be considered patentable because it lacked a sufficient technical contribution beyond mere automation.
Just making something faster on a computer wasn't enough.
Not necessarily, not if it didn't solve a technical problem in a technical way. A UK case illustrating this early thinking is Rei Fujitsu's application in the Court of Appeal. There, a computer method for processing crystalline structures was rejected because it was seen as just mechanizing a known manual task. The UK courts initially followed this Vicom-style approach.
But the EPO's thinking shifted later. They didn't stick with that.
Yes, the EPO's approach evolved. The current approach, articulated in cases like PBS Partnership and Hitachi, is to first perform that initial invention check we discussed. Does the claimed subject matter have technical character at all? If it does, then the specific exclusions in Article 52 are deemed not to apply as such. The invention has cleared the initial technical hurdle.
I see.
And then you move on to assess novelty, inventive step, and industrial application against the prior art. The Hitachi auction method case is particularly important for its explanation of the policy behind this. The exclusions are designed to prevent patents on purely abstract ideas, not on things with a technical application.
And how do the UK courts respond to this evolution in EPO thinking? Do they just adopt it?
Well, the UK courts found it challenging to simply adopt the EPO's later approach, partly due to their own precedents. So in the significant combined cases of Aerotel Ltd v. Telco Holdings Ltd and McCrossen's application, the Court of Appeal, led by Jacob L.J., devised a distinct four-step test specifically for assessing the S.12 exclusions. This is sometimes called the Aerotel-McCrossen test. You should probably jot these down.
Okay, the Aerotel-McCrossen 4 steps.
Right. Step 1, properly construe the claim, understand what it's actually claiming. Step 2, identify the actual contribution the invention makes. What's the real advance? Step 3, ask if that contribution falls solely within the list of excluded subject matter in S.12. And step 4, check whether the actual or alleged contribution is actually technical in nature.
So the UK created its own test. Did the EPO endorse this? Were they happy with it?
Not exactly. The EPO, in a later decision like Dunn's Licensing Associates, reviewed the UK's Aerotel-McCrossen test and effectively said, politely, our way is better. They reiterated their approach of first asking if there's an invention technical character and then assessing patentability, arguing that the Aerotel test added unnecessary complexity and didn't fully align with the EPC.
Okay.
Despite this, UK courts since Aerotel, like in Astron Clinica Ltd and Symbian Ltd, have largely continued to apply the four-step test, although sometimes acknowledging the difficulties in reconciling it fully with the EPO's current jurisprudence. So for students listening, understanding both the EPO technical character first approach and the UK's four-step Aerotel test is important. You need to know both exist and how they differ.
Let's dig into a few of those specific S.12 exclusions then. Discoveries, scientific theories, mathematical methods. What are some examples there?
As we touched on with the initial definition of invention, these are seen as abstract concepts. A pure discovery, like identifying a new species of plant or figuring out a fundamental scientific principle, is not patentable as such. Patent law protects the application of knowledge, not the knowledge itself.
Right.
The line, however, can be fine. The Chiron v. Organon, No. 12 case we discussed earlier, illustrates this perfectly. Identifying the hepatitis C virus was a discovery, but the patent was valid because it claimed practical technical diagnostic kits that applied that discovery.
A tangible application.
Exactly. Aldous LJ in Refujitsu's application also stressed the need for a practical application beyond the pure method.
Aesthetic creations.
Things like architectural plans, musical compositions, or paintings, these are explicitly excluded. An old case is EST's application for architectural plans. Patent law isn't the right place for these. They are better protected by copyright or design law, which are designed for artistic and aesthetic works, not technical solutions.
Makes sense.
Then you have the broad category of schemes, rules, or methods for performing a mental act, playing a game, or doing business, and relatedly, computer programs. Before Aerotel-McCrossen, UK courts often rejected patents in these areas if the invention simply automated a task previously done purely by the human mind or using non-technical methods. For example, Raytheon's application was rejected because the automated ship identification system simply mechanized a task previously done by human observation and calculation.
Just doing what a human did, but faster.
Essentially, yes, without adding a novel technical dimension. Similarly, Merrill Lynch's application involving an automated securities dealing system was seen as merely automating an existing method of trading, lacking a necessary technical contribution.
Computer programs are clearly a massive area of technology. How has the as such exclusion played out specifically for software patents? It must have been complicated.
It's been a complex journey, yes. It reflects the difficulty the law has had in adapting to the digital age. At the EPO, there have been distinct phases. The initial Vicom approach in Phase 1 asked if the program machine achieved a technical advance. Phase 2, influenced by IBM computer programs, became more nuanced, stating that only computer programs lacking technical character were excluded. Programs that produced an additional technical effect, something beyond the normal operation of hardware, like making the computer run better or controlling an external process, could be patentable.
An additional technical effect. Okay.
This was partly a response to perceived more liberal approaches in the US and Japan. The UK IPO adopted guidance reflecting this Phase 2 thinking for a time. Phase 3, with PBS partnership, introduced the any hardware approach. The apparatus running the program might be patentable, but the program process itself might not be. A bit confusing.
Right.
And as we discussed, the current thinking, as seen in Dunn's Licensing Associates, circles back to that initial technical character test. Does it have technical character? Yes. Okay, now check novelty, inventive step, etc.
So, is it fair to say that historically, many UK cases rejected software patents for lack of technical effect before the Airtel-McCrossan test was established?
Yes, absolutely. Cases like Merrill Lynch, Gale's patent that was a method for calculating a square root stored in hardware, rejected for lacking technical effect, and Refujitsu's application are examples of this. There were exceptions, of course. Quantel v. Spaceward Microsystems Ltd., where a computer graphics system was found to have a sufficient technical contribution, was one. The Airtel-McCrossan test was partly an attempt by the UK courts to create a clearer framework for evaluating these types of inventions under S.12.
And presentation of information, what does that cover?
This exclusion covers things purely about how information is displayed or conveyed. Attempts to patent the design of an advent calendar, read Townsend's application, or a specific bus display system, Ree Crawford's patent application, were rejected on this basis. It's about the format or layout, not a technical process using the information. The mental act exclusion within S.12c is generally interpreted narrowly these days, as noted in Halliburton Energy Services, Inc.'s application.
Okay.
It's also important to remember that the UK and EPO maintain a strong stance against patenting business methods as such. This contrasts with historical practice in the US. A business method claim needs to be tied to a technical means or produce a technical effect to be considered patentable here.
So that covers the first basket of exclusions, those based on lacking technical character as such. What about the second type, the public policy or morality exclusions? These apply even if the invention is technical.
Exactly. These are inventions that might otherwise meet the criteria. They might be novel, inventive, industrially applicable, and technical, but are excluded for broader societal reasons. They are found in S.13, PA 1977, Schedule A2, Section 4A, and Article 53 EPC. This area has been significantly influenced by EU law, particularly to Biotech Directive 9844/EC, which has led to amendments in both the EPC implementing regulations and national laws like the UK's.
Public policy or morality, what's the core idea behind this exclusion? What kind of things are we talking about?
Section 1.3, echoing Article 53A EPC and Article 27.2 of the TRIPS Agreement, excludes inventions whose commercial exploitation would be contrary to ordre public, which means public policy or morality. Schedule A2 lists specific examples, many drawn directly from the Biotech Directive. Things like processes for cloning human beings, processes for modifying the germline genetic identity of human beings.
Right, very sensitive areas.
Extremely. Also, uses of human embryos for industrial or commercial purposes, and processes for modifying the genetic identity of animals, which are likely to cause them suffering without any substantial medical benefit to man or animal, and also animals resulting from such processes. The EPO has historically been cautious about applying the morality exclusion broadly. They generally don't see themselves as universal moral arbiters.
They don't want to be the morality police.
Pretty much. Controversial technology isn't automatically barred. They try to balance potential benefits, like medical advancements, against potential harms, but the burden is high on those challenging a patent to prove significant, documented risks. Cases like Harvard-Onco mouse, the genetically modified mice susceptible to cancer plant genetic systems involving herbicide-resistant plants, Howard Florey relaxin concerning a human gene, and Leland's Stanford modified animal covering various transgenic animals, these all illustrate the EPO's general reluctance to refuse patents solely on broad morality grounds, often finding a potential benefit outweigh the concerns raised.
But there was one major case that did apply the morality exclusion, right? The stem cell one?
Yes, a very significant one from the EPO Enlarged Board of Appeal, G206 Wharf stem cells. This case involved a patent application related to human embryonic stem cell cultures. The board connected the General Morality Clause, Article 53A, to the specific exclusions from the Biotech Directive implemented in the EPO rules. They held that a patent could not be granted for an invention if the performance of that invention necessarily involved a step that was contrary to public policy in this case, the use and destruction of human embryos to obtain the stem cells needed for the invention.
So the invention itself required the problematic step.
That was the key finding. This was a crucial ruling, although the board limited it specifically to inventions that required embryo destruction at the time of filing. The Court of Justice of the EU has also interpreted the Biotech Directive exclusions in this area. Important cases are C3410 Oliver Brussel v. Greenpeace EV and C36413 International Stem Cell Corporation v. Comptroller General of Patents, Designs, and Trademarks. These cases clarified what constitutes a human embryo under the directive's exclusion, which is implemented in the UK's Schedule A2. The International Stem Cell Corporation case, for instance, clarified that an unfertilized ovum stimulated by parthenogenesis is not a human embryo if it cannot inherently develop into a human being. So the science matters.
What are the other key policy exclusions? Plants and animals.
Yes, a major one is the exclusion of animal and plant varieties and essentially biological processes for their production. This is in EPC Article 53B and the UK's Schedule A2, Paragraph 3F. This goes back to the discovery versus invention line. You can't patent something found in nature as such, but a technical process to produce it, or a synthetic version, can be patentable. Think Re-American Cyanamid, Dan's patent, American Cyanamid v. Burke, and the Biotech Directive Article 5.2.
Okay, so what does that exclusion in paragraph 3F actually cover?
It has several layers. First, animal varieties. Like the invention point, this is interpreted taxonomically, a claim covering a specific defined animal variety is excluded. But a broader claim, say to a genetically engineered animal that isn't limited to one variety, might not be caught, as seen in Harvard-Onco mouse.
So claiming mice might be okay, but claiming a specific breed might not.
Something like that, yes. Second, plant varieties. Similar principle. Claims covering specific plant varieties are excluded. Lubrizol hybrid plants, plant genetic systems. This is partly because there's a separate system for protecting plant varieties under the UPOV Convention. Third, essentially biological processes. The test here is the degree of human technical intervention. Traditional crossing and selection methods are excluded because they rely on natural biological phenomena. Processes involving significant technical intervention, like genetic engineering, are not excluded under this heading, plant genetic systems.
And that got complicated recently.
Yes, recent EPO cases like Plant Bioscience broccoli and State of Israel tomatoes have clarified that even if technical steps are involved within a breeding process, if the overall process is fundamentally crossing and selection of whole genomes, it's still considered essentially biological and thus excluded. And fourth, microbiological processes. These are patentable. The EPO has suggested these are processes not visible to the naked eye, typically involving microorganisms, plant genetic systems.
And there was that big legal fight about patenting the products of those biological processes.
Yeah.
The tomatoes and broccoli saga.
Oh, absolutely. This was a long and complex saga, really demonstrating how policy and legal interpretation can clash and evolve. The EPO Enlarged Board initially ruled in G212 tomatoes II and G312 broccoli II that while the essentially biological process wasn't patentable, the resulting plant or animal product itself could be.
That seems counterintuitive.
It was controversial. Their reasoning was that the exclusion in Article 53B explicitly mentioned processes, not products. However, this caused quite a stir, leading to changes in the EPO rules influenced by the European Commission, specifically to prevent such patents. Then, confusingly, an EPO technical board in T106308, the Pepper case, seemed to ignore the rule change, arguing the earlier enlarged board decisions were binding.
Oh, dear.
Exactly. This forced the issue back to the enlarged board in G319 Pepper. In that decision, the EBA finally reversed its earlier stance, explicitly taking the rule change into account. So the clear position now, after all that legal wrestling, is that products obtained exclusively by means of essentially biological processes cannot be patented at the EPO. A crucial outcome for the biotech field. Remember that one? G319 pepper.
Okay, last major policy exclusion. Methods of treatment.
Yes, this is in Article 53C, EPC, and now Section 4A1 of the UK Patents Act 1977. It excludes methods of treatment of the human or animal body by surgery or therapy, and also methods of diagnosis practiced on the human or animal body. The core policy here is humanitarian. You don't want to hinder doctors and vets from treating patients by granting monopolies over treatment methods. That was discussed in Wyeth-Shearing's applications. It's worth noting this exclusion isn't universal globally. Australia, for instance, might allow them. Anesthetic supplies, Purity Ltd v. Riscare Ltd, but it's firmly established under the ETC and UK law.
What counts as a method of treatment? Is it just prescribing a drug or wider than that?
The interpretation is quite broad under the 1977 Act. An immunization system, for instance, was deemed a method of treatment and excluded Unilever-Davis's application. The EPO interprets diagnosis broadly, too, covering claims that involve technical steps and a resulting medical decision based on those steps. See WGN US diagnostic methods. And surgery is also interpreted broadly by the EPO. If any step in a multi-step process involves surgery, the whole claim can be excluded. The key case is G107 meaty physics treatment by surgery, which involved injecting gas into the heart.
So it's quite a strict exclusion?
Generally, yes, though it's worth noting some historical peculiarities remain. Cosmetic treatments, like treating acne in Russell euclafthanoyl peroxide or slimming in du-pantapatite suppressant, are considered outside this exclusion. They aren't seen as therapy. And there was that very frontier of the law UK case, Re Stafford Miller Ltd's application, which allowed a method of killing head lice on humans. Seems very close to therapy, but was allowed.
Are there crucial exceptions or workarounds to this medical treatment exclusion? Because otherwise, how would pharma companies get patents?
Absolutely, and these are vital for the pharmaceutical industry. Section 4A2 clarifies that equipment and substances for use in methods of treatment are patentable.
So you can't patent the surgery method, but you can patent the new type of scalpel or the anesthetic drug.
Precisely. You can patent the tools and the materials used in the method. Even more importantly, Section 4A3, based on Article 54 EPC, introduced first medical use patents. If a substance is already known, maybe it's in a chemical database or was described in an old paper, but with no known medical use, and then it's discovered to have a medical use for the first time, you can patent the substance specifically for use in that first medical method.
So the novelty comes from the use, not the substance itself.
Exactly. The novelty is borrowed from the new use, even if the substance itself is technically old.
And then the second medical use.
Correct. This came from EPO case law, famously starting with I say second medical indication. The idea was extended. If a known substance already has a known medical use, say aspirin for pain relief, and then it's found to have a new inventive subsequent medical use, say aspirin for preventing heart attacks, you can patent the substance specifically for that new use. This is now explicitly allowed by Section 4A4 PA 1977 and Article 54.5 EPC. UK courts initially accepted this concept with some reluctance, Wyeth-Shearing's applications, but it's now standard practice. A classic example often cited is American Home Products Core v. Novartis Pharmaceuticals UK Ltd, where rapamycin, previously known as an antifungal, received a second medical use patent for use in transplant surgery.
Does the new use have to be for a completely different disease, or could it be, say, a new way of using the same drug for the same disease?
Not necessarily a different disease. The scope has broadened significantly. The Supreme Court and EPO Enlarged Board have confirmed that patenting a specific, new, and inventive dosage regime for a known substance can be patentable under the second medical use provision. This came up in Actavis UK Ltd v. Merck and the EPO case G208 Abbott respiratory dosage regime. The key is that the claim must be for the substance for use in that specific dosage regime, provided it's genuinely new and inventive, and not simply a claim to the method of treatment as such.
So finding a better dosing schedule could be patentable.
Potentially, yes, if it provides a new technical effect and isn't obvious. However, simply finding the optimum dosage for a natural substance without demonstrating an unexpected therapeutic advantage might not be enough. That was the issue in Bristol-Myers Squibb Company v. Baker Norton Pharmaceuticals Inc. concerning the cancer drug Taxol.
And that's where Swiss form claims fit in historically. I remember hearing that term.
Yes, exactly. Swiss form claims were the clever workaround used before the EPC was amended to explicitly allow second medical use claims via Article 54.5. The claim was phrased as use of substance X for the manufacture of a medicament for treatment of disease Y. It claimed the manufacturing process, which wasn't a method of treatment
Well,
itself.
that's a bit convoluted.
It was, but it worked. While these Swiss-type claims aren't strictly necessary for new applications now because we have S.4a Art 54.5, many existing patents are still in this format. Their interpretation, especially regarding infringement by generic drugs, has been complex, leading to major litigation like the Supreme Court case Warner-Lambert v. Activists.
Okay, so summing up the exclusions, we've got those in S.12 Art 522 for things lacking technical character as such, where the UK and EPO have slightly different tests for applying that as such. Caveat, remember Aerotel versus the EPO approach. And then the policy morality exclusions in S.13, Schedule A2, S4 Art 53, covering morality issues like stem cells, WARF, certain biological inventions, especially plants, animals, and the complex history on products, remember pepper, and methods of medical treatment. But with those crucial exceptions, allowing patents for medical substances and their first and second and subsequent medical uses, including dosage regimes.
Exactly. They function as gatekeepers, defining what kind of subject matter the patent system is intended for and what areas are deliberately left outside its scope, either because they're too abstract or for specific policy reasons. Getting past these is the first hurdle.
Right, so if an invention has technical character and isn't on any of those exclusion lists, the first positive hurdle it must clear is novelty. It simply has to be new.
Correct. This is the first of the three positive requirements, governed by Section 2 of the Patents Act 1977, which is based on Article 54 EPC. Section 2.1 states the basic rule. An invention is new if it doesn't form part of the state-of-the-art. And Section 2.2 defines the state-of-the-art very broadly. It's everything made available to the public anywhere in the world, by written or oral description, by use, or in any other way before the patent's priority date.
Everything, anywhere.
Everything, anywhere. That's the standard. There's a limited exception in S.24 for information disclosed improperly, like in breach of confidence, but only if the patent is filed within 6 months of that disclosure. Now, to assess novelty, the House of Lords, in the really important case of Synthen BVV SmithKline Beecham Pleck, laid out a two-step process. You should remember this one. Synthen.
Okay, Synthen. 2 steps.
You look at the alleged piece of prior art and ask two questions, sequentially. 1. Was the information in that prior art accessible to the public? This means, was it made available to at least one person who was legally and equitably free to use it without confidentiality obligations? This is the disclosure step. 2. If it was accessible, did that information anticipate the invention? Crucially, did it contain an enabling disclosure? This means, did the prior art provide enough information that the skilled person using their common general knowledge could actually perform or carry out the claimed invention without needing undue experimentation or invention themselves? This is the enablement step. Disclosure and enablement.
That skilled addressee person again, they're everywhere in patent law.
They absolutely are. That hypothetical person is your constant reference point. Novelty is assessed objectively through their eyes. What would they understand and be able to do based on the prior art? And critically, you always compare the claims of the patent application to the prior art. The claims are the legal definition of the invention, the fence posts around the protected territory.
Who counts as the public? Does it have to be widely known? Does it have to be published in a journal?
No, not necessarily widely known. As confirmed in cases like PLG Research Ltd v. Arden, it can literally be just one person, but that person must be legally free to use the information. Information given in confidence may be expressly under an NDA, or impliedly like in a joint venture, as in Regali doesn't destroy novelty because the recipient isn't free to use it.
But it can be tricky.
It can. If information is circulated very widely, even with a confidential label slapped on it, a court might find that confidentiality wasn't realistically maintained, as suggested in Riedel Rumpel.
Okay. And can you combine different pieces of prior art to argue something isn't new? Like take a feature from document A and another from use B.
Absolutely not for novelty. This is a fundamental rule and a key distinction from inventive step, which we'll get to. For novelty, you look at each individual item of prior art separately, a single document, a single instance of prior use. If that single item doesn't contain every single feature described in your claim, then your claim is considered novel over that specific item.
So no mosaicing for novelty.
Exactly. You cannot mosaic or piece together elements from different items to destroy novelty. The invention might still fail later for lack of inventive step when you can combine things, but it clears the novelty hurdle against that specific piece of prior art. This is vital to grasp. Also, the 1977 Act made significant changes to novelty compared to the old 1949 Act, which you should be aware of, especially if reading older cases.
What changed?
Two big things. First, prior art under the 1977 Act is worldwide, not just UK disclosure as it largely was before. Anything publicly disclosed anywhere counts. Second, and crucially for prior use under the 1949 Act, prior use could destroy novelty even if the public couldn't figure out how the invention worked just by looking at it. That was the situation in Gore v. Kemal. The 1977 Act requires an enabling disclosure for all forms of prior art, both publication and use. Riasahi KKK's patent confirmed this change, so secret or non-informative prior use generally doesn't kill novelty anymore. Be careful with older cases on prior use. The law is different now.
What kinds of things count as prior art, then? How can information be made available?
As Lord Hoffman famously put it in Merrill Dow v. Norton, the whole patent system operates on information. Prior art is simply information made available to the public. This is most commonly documents earlier patents, granted patents or published applications, scientific papers, textbooks, magazines, even sales brochures like in Monsanto Brignac's application. If it was in a publicly accessible library, even an old dusty book, it potentially counts. Re Tekalemit, re Bakelite. For written prior art to be enabling, Lord Hoffman in Synthan v. SmithKline Beecham, quoting the old case Hills v. Evers, said the skilled person must be able to at once perceive, understand, and be able practically to apply the invention described without needing undue experiment or invention.
So the description has to be clear enough to work from.
Yes. And prior use is also prior art. This could be used by the inventor themselves before filing, subject to that 6-month grace period in S.24 if it was disclosed improperly, or used by a third party, Fomento v. Metmore, or even a competitor, Bristol Myers Co. Johnson's application. Under the 1977 Act, the test for prior use destroying novelty is enablement. Could a skilled person observing that public use have deduced and performed the claimed invention?
Can you give us some examples of prior use cases? They seem quite fact-specific. How does that enablement test work in practice?
They are very fact-specific, yes, and it comes down to what the hypothetical skilled observer could reasonably deduce. A leading case, often cited, is Lux traffic controls v. Pike signals. In Lux, testing traffic lights incorporating a new type of detector on a public highway was held to destroy novelty. Why? Because the court decided a skilled observer could have figured out the essential features of the detector just by looking at its external appearance and how it operated in response to traffic.
Wow, just by watching it work.
In that case, yes. Compare that to Paul v. Bedford hydraulics. Filters were supplied to customers for testing, but the internal workings couldn't be analyzed without destroying the filter. So their supply didn't provide an enabling disclosure of the internal structure, no novelty destruction there. Public demonstrations can destroy novelty if they're enabling. Windsurfing International Inc. v. Tabor Marine is a classic example, showing the windsurf board. A demonstration in Wheatley's application also killed novelty. But not always. If observation isn't enough for the skilled person to understand and replicate the invention, like the complex electronics in Quantel v. Spaceward Microsystems, then the demonstration might not be enabling.
Location matters too. Public road versus private land.
Location can matter. Folding Attic Stairs Ltd v. The Lock Stairs Company Ltd. raised the question of whether use on private premises, even with visitors present, constitutes making available to the public in the same way as use on a public street. A very recent and illustrative IPEC case is Clayton Yieldometer Ltd v. Missouri Ltd. This involved testing a prototype seed drill on private farmland.
So private land seems okay.
Not necessarily. The problem was the testing was visible from public roads and footpaths nearby. The judge, Hakon J., had to consider what a skilled observer standing on the footpath could deduce. He ruled against assuming the observer would have fancy technical aids like zoom lenses unless there was specific evidence for it. He decided the skilled observer could deduce the key features of the invention just from the visible operation of the drill on the field.
So even visible from a distance on private land killed it.
Yes. It was deemed an enabling prior use, destroying novelty. These cases, especially Clayton, show how strictly prior use is assessed. Even limited public visibility can be fatal if it's enabling.
So anticipation is the legal term for lack of novelty. If the prior art anticipates it, it's not new.
Yes, that's the term of art. If a single piece of prior art contains an enabling disclosure of everything claimed in your patent, it anticipates the invention, meaning the invention lacks novelty. The three famous, largely interchangeable tests for what constitutes an enabling disclosure in prior art come from Sachs L.J.'s judgment in the old but still leading case General Tire v. Firestone. Modern cases, including the Supreme Court in Synthon, continue to endorse General Tire as laying down the correct tests for anticipation.
And that skilled addressee is key to whether the prior art points inevitably towards the invention without undue burden.
Exactly. The skilled person must be able to put the invention into practice based only on the prior art document or use, combined with their common general knowledge, without needing inventive thought or excessive trial and error. It has to be pretty much laid out for them. There's some academic debate noted in the sources about which of the General Tire tests Lord Hoffman preferred over time. He seemed to shift his emphasis slightly between Merrill Dow v. Norton and Synthon v. SmithKline Beecham, but the core principle of enabling disclosure remains.
Just to reinforce for everyone listening, if one item of prior art doesn't have every single piece of the claim, it's still novel over that item.
Precisely. Novelty is a strict feature-by-feature comparison against each item of prior art individually, element by element. If the prior art misses just one claimed feature, the claim is novel over that art. But remember, just because something is novel doesn't automatically make it patentable. You then move to the next, often more challenging, hurdle, inventive step.
Final quick point on novelty. Novelty of purpose. You mentioned this briefly with medical uses.
Yes, this relates closely to the first and second medical use concepts we discussed under exclusions, but the principle can apply elsewhere too. The EPO, in a key decision, Mobile 3 friction-reducing additive, allowed a patent for using a known substance for a completely new, non-medical purpose. The substance was known as a rust inhibitor, but Mobile discovered it also worked as a friction-reducing additive in engines.
So finding a new job for an old chemical.
Essentially, yes. UK courts, though initially hesitant, Merrill Dow v. Norton, accepted this principle, as seen also in Bristol-Myers Squibb Company v. Baker Norton Pharmaceuticals, Inc. It's about finding a new, non-obvious use for something old. The novelty lies in the purpose.
So even if the substance itself is old, finding a genuinely new and inventive application for it can satisfy the novelty requirement for a use claim.
Yes, provided that new use wasn't already known or obvious from the substance's inherent properties or previous disclosures. It's about the specific application adding the necessary novelty.
Okay, on to the second positive requirement. So something can be brand new novel, but still not patentable if it lacks an inventive step.
Exactly. This is where the law assesses whether the invention represents a sufficient technical advance beyond what already existed. Is it clever enough? It's covered by Section 3 of the Patents Act 1977, based on Article 56 EPC. The key requirement here is that the invention must not be obvious to a person skilled in the art. This analysis always follows the novelty assessment. You only consider inventive step if you've decided the invention is novel. Think of it this way. Novelty is about difference. A quantitative question, is it the same or different? Inventive step is about the quality or significance of that difference. Is the difference big enough, clever enough, or just an obvious tweak? It's qualitative.
How do you decide if something is obvious? That sounds subjective, even more than novelty, perhaps.
This is the perennial challenge in patent law. Obviousness is treated as a question of fact, often called a jury question, for the judge to decide based on the evidence, and it must be determined objectively, but crucially, without any benefit of hindsight. This is probably the single most important rule for obviousness.
No hindsight. Easy to say, hard to do.
Extremely hard to do. You have to consciously put aside your knowledge of the invention itself and imagine yourself back at the priority date. You look at the prior art and the common general knowledge available then and ask, would the claimed invention have been obvious to that hypothetical skilled person? It's tough because once an invention is known, especially a simple or elegant one, it often seems obvious in retrospect. The Viagra case, Lilly Ico Ltd v. Pfizer Ltd, is a classic example. The invention involved using a known type of drug for erectile dysfunction. It was ultimately found obvious because the prior art contained suggestions pointing towards trying that class of drug, even if not the specific drug claimed. The court felt it was just implementing prior suggestions. Even with seemingly simple everyday items like the deep fat fryers and Seb's AE v. DeLonghi Spy, the court must rigorously apply this objective non-hindsight test.
Are there other phrases courts use for obvious? What's the threshold?
Yes, judges have tried to capture the idea with phrases like very plain, so easy that any fool could do it, though that's probably too high a bar, routine development work, or just a workshop adjustment, or mere tweak. Conversely, an inventive step might be described as involving a flash of insight, an intellectual jump, providing an unexpected technical effect, or overcoming a technical prejudice in the field.
Is there a structured way courts approach the obviousness test? Or is it just a gut feeling?
No, it's definitely not just a gut feeling. The UK courts use a structured approach derived from the steps originally laid out by Oliver L.J. in the Windsurfing International v. Tabor Marine case, which the House of Lords approved. This test was later helpfully reordered and clarified by Jacob L.J. and Pozzoli's PAA v. BMO essay. This Pozzoli test is the standard framework used in UK courts today to assess inventive step. Remember Pozzoli?
Okay, windsurfing refined by Pozzoli.
Exactly. And yes, that notional skilled addressee and their common general knowledge are absolutely central to every step of the Pozzoli test.
Okay, let's go through the Pozzoli test steps. What are they?
Right. Drawing from the source material here, the steps are typically applied like this. Step 1. Identify the notional skilled person and identify their relevant common general knowledge, CGK. Who is this person in the relevant technical field? What do they know as standard practice? What literature would they typically read? What are their skills and capabilities? Step 2. Identify the inventive concept of the claim in question. What is the core technical idea or the essence of the claimed solution? Step 3. Identify the differences between the matter cited as prior art, usually the closest piece, and the inventive concept of the claim. What's new compared to what was known? Step 4. Ask whether, viewed without any knowledge of the invention as claimed, those differences constitute steps which would have been obvious to the skilled person, or whether they require any degree of invention. Would that skilled person, armed with the prior art and their CGK, have been naturally led to bridge those differences and arrive at the claimed invention?
And again, this is purely objective, nothing to do with how the actual inventor came up with it, whether they struggled for years or had a lucky break.
Absolutely. The method of invention, whether it was inspiration, methodical research, hard work, or pure accident, is legally irrelevant to patentability. The test is solely what would have been obvious to that hypothetical skilled person at that moment in time. That was established way back in Allmänna Svenska Elektriska ABV Berntivineland Shipping Co.
What kind of prior art is relevant for inventive step? Is it limited like with novelty, just one document at a time?
Look at each item individually for inventive step. You can consider all relevant prior art that would have been available to the skilled person. That was established in windsurfing.
All of it.
All of it that forms part of the state of the art. This includes everything publicly available, all publications, all uses anywhere in the world. A recent Court of Appeal case, Emission and Sons, Inc. v. Hoslock Ltd., reinforced this broad approach. They found a patent for an expandable garden hose, obvious based partly on a prior document about aeronautical hoses.
Aeronautical hoses for a garden.
Yes, because the court decided the relevant technical principles were disclosed, and the skilled person in the garden hose field would look at adjacent fields like general hose technology if faced with a problem. It confirmed the strict application of the Pozzoli test, even with potentially obscure prior art, as long as it's part of the state-of-the-art.
And that's where mosaicing comes in properly, combining documents.
Yes. For inventive step, you can try to argue that the invention is obvious by combining features from different pieces of prior art. This is called mosaicing. However, it's generally hard to succeed with a mosaicing argument. You have to show not just that the different pieces of information existed, but that the skilled person would find it obvious to select and combine those specific pieces in the specific way claimed in the patent.
Why is it hard?
Because remember, the skilled person has no inventive capacity. They aren't creative. They only do what's obvious. You need to show some motivation or reason, a pointer or suggestion in the prior art or common general knowledge that would lead the skilled person to put those specific pieces together to solve the problem the patent addresses. They wouldn't just randomly combine unrelated documents. Dow Chemicals, Ladner's patent, is sometimes cited as a rare example where mosaicing was accepted by the court. Seb Sav de Longis B.A., the Fryer case, also discussed the difficulty of making mosaicing arguments stick.
What about inventions that are just a combination of features that are all known separately, like sticking A and B together?
This is also assessed under inventive step, and is where the concept of collocation is relevant. If you combine known features, A and B, but they simply perform their individual known functions alongside each other, without any new, unexpected interaction or synergistic effect resulting from the combination itself, that's likely a mere collocation.
Just putting things together.
Exactly. It's not considered an inventive combination, and it probably lacks an inventive step. The Supreme Court clarified this in Saboff, CPA v. MFI Furniture Centers Ltd, applying EPO guidelines and earlier UK cases like British Celanese Ltd v. Courtaulds Ltd. The classic textbook example often used is combining a known mincing machine and a known sausage filling machine to make a single machine that minces and fills sausages. Each part just does what it always did. There's no inventive synergy in putting them next to each other, it's a collocation. However, if the combination does produce a surprising technical effect, or overcomes a known technical prejudice against combining those features, then it could well be inventive.
Are there other things courts might consider, sometimes called secondary indicia or secondary factors of non-obviousness?
Yes, patentees often try to use these to bolster their argument for inventiveness, especially if the core technical argument based on the Pozzoli steps is borderline. These are things like evidence of a long-felt want for the invention. People were trying and failing to solve this problem, the failure of others to achieve it, or the commercial success of the patented product, arguing people bought it because it was inventive. However, UK courts treat these factors as strictly subsidiary to the primary objective application of the Pozzoli test. They are viewed with caution, as confirmed in Beloit Technologies v. Valmet Paper Machinery. They can sometimes tip the balance, but they can't rescue an invention that's clearly obvious on the technical merits.
Why the con?
Well, evidence of a long search or the failure of others can suggest inventiveness, implying the problem wasn't obvious to solve. Beecham's amoxicillin application, where it took Beecham 6 years to find a specific new antibiotic formulation in a highly competitive field, is an example where this carried weight. But a long development time might just mean a company threw a lot of resources at routine screening, not necessarily that it required inventive genius, Genentech Inc.'s patent. And commercial success is often particularly misleading. It can easily be due to clever marketing, brand loyalty, fashion trends, Wild E.V. Freeman, pricing, or other non-technical factors rather than the technical inventiveness of the product, Haskell Golf Ball Co. That said, if an invention is found to be inventive based on the Pozzoli test, its apparent simplicity shouldn't be held against it. That was the point in Haberman v. Jekyll International Ltd. with the Anyway Up Cup.
The Supreme Court recently revisited the inventive step test, particularly for things like dosage regimes. You mentioned Activist v. ICOS earlier.
Yes, in the very significant case of Activist Group v. ICOS Corporation, dealing with that second medical use claim covering a specific low-dosage regime for tadalafil, Cialis. Lord Hodge gave the leading judgment and reviewed both the UK's established windsurfing Pozzoli approach and the EPO's slightly different problem-solution approach. He stressed that neither approach should be applied rigidly or mechanistically like a tick-box exercise. The ultimate question is always whether the invention was obvious under Section 3. Crucially, he endorsed considering a list of factors previously identified by Lord Kitchen when he was Kitchen J in the High Court in Generics UK Ltd VH Lundbeck. These factors can help the court apply the statutory test in a structured but realistic way.
What are some of those factors from the Kitchen J list that Lord Hodge endorsed? What kind of things should the court think about?
These factors are intended to guide the analysis of obviousness, especially in complex technical fields like pharmaceuticals. They include things like, was the invention obvious to try? Did the prior art indicate a clear path worth pursuing with a reasonable expectation of success? Was the necessary research routine, or did it involve significant difficulty or uncertainty? What was the cost and burden involved in carrying out the research program? Were there important value judgments the skilled person had to make along the way? Were there many alternative research paths the skilled person might have taken instead? What was the actual motivation for the skilled person to pursue the specific path leading to the invention? Were the results unexpected or surprising, or were they predictable? And always the absolute importance of avoiding hindsight. Plus, an interesting one, whether a feature provides a technical benefit even if its inclusion was obvious for a different purpose.
That's a comprehensive list to consider.
It is. And in the specific context of dosage patents, the court in Activist v. ICOS noted that skilled pharmaceutical teams typically aim to find the lowest effective dose through routine dose-ranging studies. This makes claims to specific low doses particularly susceptible to being found obvious. In Activist v. ICOS, the Supreme Court upheld the Court of Appeals' finding of obviousness, agreeing with the trial judge's assessment of the evidence. They concluded that a skilled team, starting from the known higher dose, would have likely tested lower doses as part of routine development work and arrived at the claimed low-dose regime without invention. This case really underscores that applying the obviousness test requires a careful, fact-specific analysis guided by these kinds of factors and always, always guarding against the siren call of hindsight.
Okay, that's novelty and inventive step covered in detail. The final positive requirement is that the invention must be capable of industrial application.
Correct. This is covered by Section 4 of the Patents Act 1977, derived from Article 57 EPC. Compared to novelty and especially inventive step, this requirement is often the least litigated and usually the easiest one to satisfy in practice. It's essentially the modern equivalent of the old requirement under the 1949 Act for an invention to be a manner of new manufacture.
What does capable of industrial application actually mean? Does it mean it has to be mass-produced in a factory?
No, not necessarily mass-produced. Under the old 1949 Act law, the concept evolved from needing a vendable product, something you could sell, as suggested in GE's application, to requiring some form of economic utility or demonstrable useful effect, as established in the Australian case NRDC's application, which was influential in the UK. Under the 1977 Act, the interpretation has generally been quite broad. Cases like Chiron v. Organon, No. 12, suggest it means simply that the invention must not be completely useless for any known purpose. The core idea is usefulness and the ability to be made or used in any kind of industry. And industry is interpreted broadly, specifically including agriculture.
So what kinds of things would fail this test?
Usually things that are fundamentally flawed or impossible. Inventions that clearly defy established laws of physics, for instance. An example given in the sources is Reduct's patent application for an engine claimed to have perpetual motion or produce more energy than it consumes. That's impossible, so it lacks industrial application. Another example is Blacklight Power Inc. v. Comptroller General of Patents. This involved a claimed plasma reactor based on a hypothetical, non-existent state of hydrogen. Since the underlying science was deemed non-existent, the invention couldn't possibly be made or used, so it failed on industrial application.
So if it just plain doesn't work according to known science, it's out.
Pretty much. The patent system isn't for science fiction.
What about inventions that are very early stage, maybe where you've identified something new but aren't totally sure of all its uses? Like identifying a new protein sequence through bioinformatics, but only being able to suggest potential therapeutic uses based on computer modeling? Does that count as useful enough?
This was the core issue in the very important Supreme Court case of Eli Lilly and Company v. Human Genome Sciences, Inc. It's a key case for industrial application, especially in biotech. The patent claimed a newly identified protein sequence, a gene product called Nutrikine, and listed a whole range of potential therapeutic applications based primarily on bioinformatics analysis, suggesting it belonged to a known family of proteins involved in the immune system. The Court of Appeal initially found the patent invalid for lacking industrial application. They felt the claimed uses were too speculative at the time of filing.
Too much guesswork.
That was the feeling. Jacob L.J., applying the skilled accuracy test, concluded that the sheer breadth of claimed potential uses without much concrete biological data yet would seem like total guesswork or totally far-fetched to the skilled person. They felt the inventor didn't have a clear, concrete, and plausible idea of the protein's actual utility.
But the Supreme Court took a different view. They overturned that.
Yes, the Supreme Court reversed the Court of Appeal's decision. Lord Neuberger gave the judgment, providing a detailed review of the EPO's established principles on industrial application, which are generally quite lenient. The Supreme Court held that the patent was capable of industrial application. They clarified that you don't need to have proven every single potential use or even know the exact biological mechanism at the time of filing. If the patent specification discloses at least one plausible or reasonably credible use for the invention and describes it sufficiently for the skilled person to understand how to potentially put it into practice, even if further research is needed, then the industrial application requirement under Section 4, Article 57 is generally met.
So a plausible use is enough.
A plausible use, described sufficiently, yes. Even with some element of speculation on future applications, if a concrete, useful purpose can be credibly identified and described based on the information available, this requirement is typically satisfied. The Eli Lilly v. HGS case shows the standard for industrial application is not excessively high. It focuses on demonstrating some utility and practical applicability, rather than demanding guaranteed commercial success or absolute certainty about all potential applications right at the start.
Wow, okay. That was a truly deep dive. We've journeyed all the way from that initial, surprisingly debated question of what even counts as an invention needing that technical character, Then we navigated through the various areas the law explicitly excludes abstract ideas like maths or business methods as such, aesthetic creations, certain biological inventions like plant varieties, and essentially biological processes, methods of medical treatment.
And explored the fascinating policy reasons and the often complex case law history behind those exclusions, like the EPO wrestling with morality in Harvard Oncomouse and Whorf stem cells, and that whole saga over patenting the products of biological processes finally settled in Pepper.
Right. And then we cleared the three big positive hurdles every patentable invention must jump over.
Exactly. First, novelty under Section 2, asking if the invention is genuinely new compared to everything in the worldwide state of the art, remembering the strict need for an enabling disclosure in a single piece of prior art, as highlighted in Synthon and General Tire, and the pitfalls of prior use shown in Lux and Cleton.
Second, inventive step under Section 3. Perhaps the most challenging, assessing if the invention is non-obvious to that crucial skilled person. Using structured tests like Pozzoli, considering all prior art, allowing mosaicing carefully, watching out for mere colligations, Zaboff, considering subsidiary factors cautiously, and above all, avoiding hindsight, as emphasized again recently in Activist v. ICOS.
And finally, third, capable of industrial application under Section 4. Confirming the invention is functional and useful in some practical way, not impossible or purely speculative, with Eli Lilly v. Human Genome Sciences setting the standard for plausibility, especially in early-stage research.
We've repeatedly seen how the UK Patents Act 1977 is so closely aligned with the European Patent Convention and the absolutely vital influence of case law from both the UK courts and the EPO boards of appeal. You really can't understand one without the other.
Definitely not. Cases like Biogen on the definition of invention, Vicom, Aretel Macrossin, and Dunn's licensing shaping the approach to technical character exclusions, the policy battles in Harvard Oncomouse, Whorf stem cells, and the Tamara's broccoli pepper decisions on biotech. They're all essential reading.
And the detailed application of the rules in cases like Metaphysics on medical methods, Synthon and General Tire defining novelty and enablement, Lux traffic controls, and Clayton yieldometer on tricky prior use scenarios.
Pizzoli and the Supreme Court's review in Activist v. ICOS, providing frameworks for inventive step, and Eli Lilly v. Human Genome Sciences clarifying industrial application. Understanding the outcome and the reasoning in these key cases is fundamental to grasping how the principles are applied. For students listening, going back over these specific cases, maybe making flashcards or notes on the key point each one illustrates, is absolutely crucial preparation for exams. Know your cases.
It really underscores that patent law isn't just a dry set of rules you tick off a list. It's a dynamic system, constantly grappling with new technologies and trying to balance incentivizing innovation with public access to knowledge and navigating ethical concerns.
Indeed. Each requirement builds on the last, and failure on any one means no patent protection. It's about finding that delicate balance, granting valuable exclusive rights to encourage technical progress, but not allowing monopolies on basic scientific principles, abstract ideas, things better covered by copyright or design law, or things that society, through parliament and the courts, deems off-limits for important policy reasons.
So as we wrap up this deep dive, particularly thinking about the rapid pace of technological change, AI, biotech, quantum computing, what's a final thought to leave our listener with, something to mull over?
Well, consider how future technologies, perhaps advanced AI, that genuinely creates novel inventions without human input, or synthetic biology that completely blurs the line between natural discovery and technical creation, or even entirely new forms of digital interaction or information processing. How will they challenge these fundamental criteria we've just spent this time discussing? Will technical characters still mean the same thing when the invention is purely informational but has profound real-world effects? How will obviousness be assessed when an AI can analyze literally all prior art and explore possibilities far beyond human intuition in seconds? These legal principles, novelty, inventive step, industrial application, the exclusions were largely designed in an earlier technological era. They're constantly being tested and reinterpreted now, and they will undoubtedly need to continue to adapt as innovation keeps pushing the boundaries of what we can even imagine today. It's a fascinating, constantly evolving area of law.
Absolutely fascinating and maybe a little daunting to think about the future implications. Thanks so much for guiding us through this complex material today.
My pleasure. I really hope it's been helpful and clarified some of those tricky points.
And thanks to you for joining us for this deep dive into patentability criteria, drawing on those excellent resources from the University of London and brought to you by Sinorbit Academy, Sri Lanka. We truly hope this has helped clarify these crucial concepts and cases. Good luck again for your studies and any exams you're preparing for. Keep diving deep.